Hello, everyone. Thank you so much for joining us today for this wonderful webinar session that we're going to be having here in partnership with Founders Wanted. We at Co-Founders Lab are extremely excited to have this webinar session. So really quickly, to give an introduction, my name is Alejandro Cremades. I am one of the co-founders of OneBest, which is the parent company of Co-Founders Lab. Really quickly on what we're doing at OneBest is basically developing an ecosystem in which we support founders as well as investors from the formation of the company all the way to the financing. So at the formation stage, we have Co-Founders Lab, in which we are connecting, as some of you may know, some of you may not, but what we do is basically connect founders with one another at a very early stage. Some of them are at an idea stage, some others are at a pre-revenue stage, and then others are more in the revenue cycle. We also connect founders with advisors, and right now we've been able to develop one of the largest ecosystems of entrepreneurs. What we're doing on the financing side is called 1000 Angels, and basically what we do there is we connect early stage startups with accredited investors. For founders, by the way, it's for free to raise money there, so that's pretty cool. And then also, just to close up here, I myself just published a book that perhaps some of you, if you are looking to raise some capital, may be interesting. It's called The Art of Startup Fundraising. Again, The Art of Startup Fundraising, and you can see that on Amazon. So without further ado, I think that we can get started here. We're going to have Founders Wanted. For those of you that are not familiar, Founders Wanted, basically what they do is they match founders with already patented ideas. We're going to have some more information from the speakers today, and we have, just to introduce them really quickly, and they're also going to introduce themselves, we have Mark Pascarella, who is the co-founder there at Founders Wanted. We also have Rich Baker, who is the VP of Acquisitions. And then we have as well Sam Parrott, who is the marketing manager. So without further ado, Sam, I'll give you the floor so that you can get started. And thank you so much for, giving this webinar. We're very, very excited.
Hey, thanks, Alejandro. It's Mark. And good afternoon, everyone, and welcome to our webinar, 11 Intellectual Property Tips Every Entrepreneur Must Know. I'm Mark Pascarella. I'm the co-founder of Founders Wanted, and I'm joined today by Rich Baker, who's our VP of Patent Acquisitions. Together, we're part of a company called Founders Wanted, and we're taking a new approach to how startups form, and it all begins with intellectual property. At Founders Wanted, we match qualified founders with patented ideas and turn good ideas into great companies. And we're really pleased to be here today and to present this webinar alongside our partners at Co-Founders Lab. We're both excited about bringing new insights, innovation, and information to entrepreneurs everywhere. And today's focus is specifically on intellectual property. That's both patents and intellectual property, or IP for short. Oftentimes, these terms are simply not discussed in startup circles. In fact, many founders shy away from or completely refuse to acknowledge the value and importance of intellectual property. And so we're here today to talk very bluntly about how you can use intellectual property in your startup to your advantage as you build a company. So by way of background, I've been an investor and software entrepreneur for the last 20 years. I'm passionate about startups, social media, and sports. And I really enjoy helping entrepreneurs conceive, launch, and grow businesses. And that's really why I'm here today. Rich, how about you? Can you provide a little background and tell us about your experiences and some of the things you're passionate about?
Sure. I'm a software engineer by training. I've also got a minor in electrical engineering, so I understand that side of the world. And after being an engineer for a number of years, I stumbled across an idea that we started to patent and got interested in the patenting process and moved over into running intellectual property departments for 3Com Corporation and for Schneider Automation, division of Schneider Electric. And now I'm working as VP of Acquisitions for Founders Wanted. So if you have some great patented ideas that you think we should start a company around, please send them in to me.
All right. Hey, thanks, Rich. Really appreciate you providing that background. And now let's get ready for today's webinar. But first, a couple quick anecdotes on the value of intellectual property. Did you know that Microsoft, which has, I think by any measure, failed miserably in the mobile phone business, generates more than $2 billion a year in licensing fees from the Android operating system? And they've done that all through a very rich and robust patent portfolio. And nearly 100% of that $2 billion is from patents.
And they're following pretty much in the footsteps of IBM, who's been doing that for 10 to 20 years, generating $1 to $2 billion a year off of their patent portfolio. They have a number of labs, great engineers there. They patent everything. And it's not unusual for them to knock on the doors of companies and say you need to take a license, and that's how they brought all that money in.
Right, and so even like Yahoo recently being auctioned, valued at around $4 billion, less real estate assets, where $1 billion of that is intellectual property value. So 25% of the total value of Yahoo as a company comes from patents and intellectual property, and I think that just speaks to the power of IP and why IP is important.
Right.
So, hey, one housekeeping note, if you have questions, please submit them at any time using the questions module on your GoToWebinar screen. All right, let's get started with today's session. The 11 intellectual property tips every entrepreneur must know. Let's run down the list here. Starting first with numbers 1, 2, and 3. Start early, start early, start early. Rich, I guess it's critical to start early if it's occupying the numbers 1, 2, and 3 position.
Absolutely.
Can you tell us why it's so important to start early? I guess you're going to give us a little detail.
Let me tell you a little bit further. Let's go through the list.
Okay, all right. So let's move to number 4, the cost of a patent. I think it's important that we get this chance to explore what it really costs to apply for and be granted a U.S. patent. Number 5, we're going to talk about the fast track. Sounds pretty exciting. And this is really going to hone in on the idea of how much time it takes to get a patent. Then number 6, don't need lawyers. Is it really true? I guess you're going to answer that for us, that you don't need a lawyer in order to file for a patent. Is that true? I guess we'll find out. All right. Number 7, the best defense is a good offense. That is interesting, and I guess we'll find out what that means as we dive into today's content. Number 8, ignorance is not bliss. This is really important. I guess we're going to talk about the fact you can't simply bury your head in the sand and ignore intellectual property.
No.
Number 9, a couple acronyms here, I suppose. I think most folks know what CYA is and what NDA means, but in this context, we'll dig into the importance of ensuring that all of your employees and contributors around your startup are part of a sound IP strategy. Number 10, IP is more than just patents. I think we all know that IP goes way beyond patents to include many other elements of intellectual property, and you're going to take us through some of those, right, Rich?
Right, and why they're important.
Right. And number 11, know your end game. And I think this is good advice in general for startup entrepreneurs. Knowing your end game is always important in the business planning process, and it's certainly important as you think about intellectual property. You need to know your end game before you get started. Okay, so let's review that list very quickly and then dive into the content. Numbers 1, 2, and 3, start early. Number 4, cost of a patent. Number 5, the fast track. Number 6, don't need lawyers. Number 7, the best defense is a good offense. Number 8, ignorance is not bliss. Number 9, CYA, NDA. Number 10, IP is more than just patents. And wrapping up in the 11th spot, know your end game.
Know your end game.
All right. Hey, we've got it. So that's the list we're going to dig into. Let's get started with numbers 1, 2, and 3. Start early, start early, start early. Okay, Rich, why is it so important to start early?
It's critical to start early, Mark. Partly because years ago it used to be the first inventor would get the patent. And that all changed around 2012, where it's now the first inventor to file with the patent office. So it becomes a race to the patent office. If you've got a new idea and somebody else invents it at the same time on the other coast, it's whoever files first gets the patent. used to be you'd go through engineering notebooks, this big debate over who was first, and you're looking back in engineering logs. You don't have to worry about that anymore. But you do have to worry about starting early and getting your idea to the patent office as quickly as possible.
And so it's no longer who invented it first, but which inventor was the first to file with the USPTO.
Exactly.
And so how do you run that process? How do you start the effort of getting an idea to the patent office? Where does it begin, and how does it work?
Often it begins with a provisional patent application, which is a rather simple process. It could be just taking what's on your whiteboard, taking some pictures, and putting it into a PowerPoint presentation and converting it to a PDF and sending it to the patent office. Pay them $130 for a small company, or could be a little less or more for some people, but mostly it's $130. And you've got something in the patent office. You've got your ideas recorded.
And so this isn't anything more than just getting your ideas on paper and collecting those. And so it sounds like, when we talk about start early, the idea is gather your ideas in a form which is quite casual to submit to the patent office.
Right.
And when do we have to do that? Right? Where exactly do we need to be when we're actually submitting those ideas?
You could be any place in the process, and the earlier the better. So if you've got a business concept that you really, really like, get it down on paper and get it into the patent office. This would be before your demos, before your trade shows, before you do papers. Because not only is it a race to the patent office, but if you're not careful, everything you say publicly can be used against you, against your patent. Now, in the United States, you get a 1-year grace period, which you've got to keep an eye on. But foreign patents, a number of foreign countries, if you've disclosed something publicly, if you've published a paper, right, it'll be used against you as prior art to say you can't get your patent. Your own work will be cited against you.
I see. So the idea here is that you need to file with the patent office before you speak publicly about what it is. So it's important, for example, to get the filing in at the USPTO before you publish a YouTube video or go on Kickstarter or get up at a trade show and give a presentation. You want to have that filing completed in advance of that public appearance, so to speak.
Right. Now, the U.S. government, the U.S. Patent Office gives you a 1-year grace period.
Okay.
But it's easy for inventors and startups as they're moving along to forget that 1-year period. I've gotten calls, at noon. We're wondering if we should file a patent. And you go out and you look on YouTube, and there's the video they put out there exactly 1 year earlier. And it's like, we've got 12 hours to get a patent on file. And we were scrambling that day and filing it a couple minutes before midnight.
You got it done?
We got it done, but
it
doesn't make friends with your patent agent.
Right. But the lesson in all this, it sounds like the real lesson here is file first, then talk about it.
Yes.
Not the other way.
That's the safest way to do it.
So, really sort of driving home that point of start early. And the collection of ideas, the submission to the patent office with just a loose set of those ideas, can be photographs, can be notes, etc. Get it on file, and then go public.
Right.
Keep an eye on the calendar.
Right, but that's why we've got this as number 1, number 2, and number 3.
With that, let's move on to number 4. Let's talk about the cost of a patent. Rich, a number of folks that I talk with say, hey, we don't have budget or time to focus on patents, right? I'm a startup entrepreneur. I'm wearing a lot of hats. I'm working really hard on growing my business, building my product. I just don't have time for patents. It leads me to ask, what does it really cost, right? If people are saying I can't afford it, there's no budget, is that true? What's it cost to get a patent?
Generally, I tell people $5,000 to $15,000. It could be 20 or 25, depending on how complicated. If you've got a very complex pharmaceutical patent, it may be $25,000 or $30,000. But you can do this for much, much less than that.
How? You can start small?
You can start small, plus you got to look at the timing of your of your investment. That's 25,000 is over 11 years, maybe.
So a number like that, 15, 20, 25,000 could be over the life of the patent.
Right.
But like as every entrepreneur knows, right, cash flow is king, and what's important is the timing of those payments. So as a startup entrepreneur, I'm much more willing to part with 10 grand in 5 years than I am with $1,000 today. So what does it cost, just to get going today, and then how do those costs grow over time?
If you want to preserve your place in line and preserve your rights, it could cost someplace, for a small entity, small business, $130 to file that provisional application.
Wait, $130.
$130.
And that gives you your place in line, holding your date of invention.
Right.
And you can do that straight away on the USPTO website?
Yes, you can.
Without involving expense and big effort? It's really just a submission of the idea?
Yes, and we'll talk in a few minutes the debate on whether to use an attorney or not.
Okay.
But
you're saying for $130 I can pay with a credit card?
Pay with a credit card.
I can start the ball rolling on the patent process?
Yes.
And feels like short money for any entrepreneur to be able to say, we have a patent in process. We filed a patent application around their idea, which is in most instances the lifeblood of their company.
And what you want to be filing is things you'd normally be writing anyways, a product spec, an architecture spec, your design spec. Those can all be just concatenated together in one big filing. So you're not doing additional extra work.
Got it.
The same work you're writing anyways.
Okay, so let's come back to this idea of holding our place in line. So I'm working with my team, a couple of folks. We come up with a product idea. We think it's unique and inventive, and we'd really like to file for a patent. So we take some of our notes, and we write it up in a 2-page report, and we submit it to the patent office online.
I'd suggest a little more than a 2-page report.
More than 2 pages?
Yeah,
okay.
I mean, it's 20-page, but that's your normal engineering spec that you're writing anyways.
So we put those together, we file them online, and it's going to cost $130.
Right.
Then what?
Then you save your place for 1 year. That's called a provisional patent application. At the end of your 1 year, you need to convert that to a non-provisional patent application, or your rights are gone. Your filing date is lost. That's going to cost you a little more money. That's going to cost something in the order of $730 for a small entity to file.
And small entity defined as?
Oh, it's under 500 employees.
Okay, so so any startup is going to fit as a small entity.
And it may actually be a micro entity, which is even less than this. But I'm not going to get.
But so we're looking at 130 followed by 730. So less than $1,000 to actually file a formal patent application over the course of a year.
Right.
And I have, not that I would ever do this, but if I do the provisional filing, I could wait till day 364, do nothing for nearly a year, and in the final day, put together the actual claims construction and the filing on a formal basis to move it to a formal patent application.
Yes, you could.
Do you advise waiting till the last minute?
It depends on your cash flow. It's a strategy question.
Okay. So it's up to the individual to decide when they file.
And what's your company? Do you have the cash? If you're cash poor, you hold it to the last second.
Got it. Okay. But the point here being that we're all in $1,000 to get this moving forward if we did it on our own.
Right. If you do it on your own.
Okay. Now let's move from cost to number 5, which is looking at the time it takes to get a patent filed, and this new thing called the fast track. And thanks to Sam Perrette for that wonderful animation. Nice work, Sam. So here's where I find myself. In addition to people saying, hey, I don't have the time or the budget to apply for patents, I have a lot of folks who say, hey, that's going to take 5 years, or in some cases longer than 5, 7, or even a decade for a patent to issue. And that's outside the window of visibility to startup entrepreneur, right? I'm thinking today, this week, this quarter, maybe this year. I can't be thinking 5 and 10 years out. I'm just trying to build my business piece by piece. And so a lot of folks will dismiss intellectual property as unimportant because it lies outside their window of visibility. Here you're saying we can do something much, much faster. So tell me, what is this fast track? How does it work? And how can startup entrepreneurs take advantage of it? I mean,
what you're talking about is right. A couple of years ago, 5 years to get a patent was not unusual. But the patent office realized that problem and said, if you want to pay us some extra money, we will put you at the head of the queue every single time. If you pay $2,800 when you, and that replaces the $730, so it's basically an incremental $2,000. You can go to the head of the line every single time, and we will guarantee we'll make a decision in 1 year that you can have a patent or not. So it's called the Track 1, or Fast Track, as a number of us call, and it works phenomenally fast. Where I was sometimes getting 4 or 5 years, I have gotten patents in the last year or two in 5 months.
So you're saying, wait, you're saying that as an entrepreneur, I could have a brilliant idea, I set to work on it, I file an application, I pay the extra $2,000, it sounds like, roughly speaking, to put it on the fast track, and within as little as 6 months, but certainly less than 12, I'm going to have my patent acted on.
If it's a patentable idea, yes.
Right, and that's pretty compelling for a startup company, right? I mean, 6 months could be even before you go out to raise any significant capital, and a new asset could be added, which is, hey, we have an issued patent, right?
Exactly. It makes patents relevant to the startup community.
Yeah, I mean, I think it's really an important piece that is not really spoken about much, right? The idea that as a startup entrepreneur, you could be 6 to 12 months into building your business and have an issued U.S. patent. That's pretty powerful.
You've got a tool there to defend your company.
And all this changed when? Because I remember years ago, it was hey, file it and forget it, and then you get a call 4 or 5 years later with some office action. Now it's as little as 12 months or less, huh?
That's correct.
When did it change?
Changed in 2012 with the American Invents Act.
So just like the last 5 years or so,
right.
People have been able to file this fast track. And
Right.
it's open to anyone.
It's open to anyone.
With a checkbook, $2,000.
$2,000, again, this is small entity prices.
Wow, it sounds almost too good to be true. I wish they could do this at the DMV. I could get in early by paying a little bit more. It would save me a lot of time. But certainly a pretty compelling opportunity for entrepreneurs to take advantage of the fast track, and it really helps them grow the value of their business by adding an intellectual property asset in as little as 12 months or less. So that's really a good piece of advice, and I hope folks in the audience grab that and run with it. I think the fast track is really a unique way to think about intellectual property for startups.
Right.
Let's move on to number 6. This is one of my favorites. If it's true, don't need lawyers. To hire a lawyer or not, do you have to have one? Is it required? I'm interested in knowing specifically how we preserve capital, how we keep costs low, and still effectively file for IP. So I ask you, Rich, is it in fact true that we don't need lawyers?
Well, yes, you can do this without a lawyer. Whether it's advisable or not, maybe another question, but yes, you can do it without a lawyer.
And advisable because why? You want the entrepreneur focused on running and growing the company?
Well, that's part of it.
Okay.
The chore of writing a patent application, it takes a while, and learning all the nuances can take a huge amount of time. You're looking for a patent that will pass muster at the patent office, that will be defensible, that you can use if you ever have to assert it to protect your product lines against a competitor. You need someone that can look ahead and see all of the pitfalls. So that's why you would need a lawyer to give you a good, rock-solid patent. But you can do this without a lawyer.
That's pretty interesting, right? If we can do it without a lawyer. I suppose there's 2 approaches. One is do it yourself.
Yes.
But then we're taking time away from building the company.
And you're taking risk
And the other extreme is hiring a lawyer.
Mm-hmm.
And what sits in the middle?
The middle is be a patent agent, which is basically an engineer who has passed the test that allows him to work with the patent office and file patents. But it's somebody that understands your field, that can draft and file, and often will file many patent applications, have a lot of as much experience as an attorney, and usually will cost about half of what you'll pay a law firm for a seasoned attorney.
Okay, so it sounds like there's some advice lying in here that would let us hack the patent process, right? It would let us really kind of crack it open and say, hey, there's some things that we can do individually as entrepreneurs like taking a product spec and building that into a patent application, and then handing that off to someone, maybe a patent agent, in advance of a patent attorney before we really have to incur significant costs.
That's correct.
So there's some DIY here, do it yourself, that the entrepreneur can advance, and they can get some help and resources that will let them do that in a way that is very cost effective.
This system allows you to build your own strategy, what's important to you, where you need to allocate your resources, and still be able to protect your idea with patents.
Cool. So let's take a look at some of the resources that might be available. I know that we talked about a couple that the USPTO has made available to folks looking to generate patents. Specifically, there's a website, there's a phone number. What are these resources? How do they work? What do they cost?
Well, the Patent Office realizes the problem of the expense of getting that most people feel that they have to pay to get a patent. So they've set up the Inventor Assistance Center, and you can talk to them at 800-786-9199. And from the way the Patent Office explains this, they take examiners, supervisory examiners, somebody that wants to get off of the patent examining side of things for a while and help inventors, and they'll answer the phone there. And they can help you work through the process of getting your patent. They won't do the work for you, but they can give you advice, help you with the forms, help you with how you need to structure the whole process. And then this efs.uspto.gov is a government portal that you file your patent applications on. It's the same as what I do as a patent agent. I use that portal to file all my customers' patent applications, and the public can use that as well to file their own patent applications if they so desire.
But you're telling me that in addition to this website, which has some good resources, I can actually pick up the phone and talk to a live human being at no cost?
Yes. Well, you've paid for it through your taxes.
Okay, but no additional cost.
That's correct.
To actually reach out to someone at the USPTO who's going to help me through the process.
That's correct.
Now, they're not going to actually write claims or anything.
No, they won't write claims. They won't draft your specification, but they'll tell you what you need, how to lay the document out, and some of the requirements.
And can you call that number, just ask questions?
Yes, that's what it's there for.
Okay. We should try it. The long hold time?
It depends on the Patent Office. Sometimes you want to call first thing in the morning.
But it's got to be easier than reaching the IRS.
Yes, it is. I've had to call both, and the call times are shorter at the Patent Office.
All right, cool. A couple good resources, and we'll certainly make these available for folks as part of the recording and available online at founderswanted.com so that you can grab these resources. And if you want to get started with intellectual property, you can begin by reaching out to the folks at the USPTO, and hopefully they can guide you through it.
Sounds good.
All right. Hey, cool. Hey, let's move on to number 7, and this is one that I like. The best defense is a good offense. Rich, that sounds like something you'd hear from a sportscaster during a game. So what does it mean in this context? What is a good defense? What is a good offense? How does it relate to patents and IP?
Well, if you're not paying attention to intellectual property, your competitors may well be. Your competitors will have patents, and they may be ready to assert those against your company. So when you start building up market share and they see that you're starting to succeed, you may get a call from one of your competitors saying, hey, you're using some of our patents. The best position to be in when you get that call is to say, we've got some patents of our own you might be interested in. And you wind up with a patent truce between the two companies, or at least paying a lot less than you would be if you're standing there naked with no intellectual property protection.
Okay, so it sounds like you're saying that one way to ensure your own defense as it relates to intellectual property matters is to have some IP of your own when that discussion might occur, if it should occur.
That's
right?
That
having your own intellectual property certainly aids in that discussion or negotiation around intellectual property. Should you get to a point where somebody wants to talk about licensing or royalties or infringement, perhaps.
Right, and as your company, say your company starts growing tremendously, if you've listened to our first 3 points and you started early, you've got your own patent portfolio. Other companies, 3Com, Google, and others didn't pay a whole lot of attention to their patent portfolios early on. They got huge and had to go out and spend huge sums of money to acquire intellectual property portfolios.
Yeah, we've probably seen a handful of examples of something like this. One of them being certainly Google, as you mentioned, went out and bolstered its intellectual property portfolio when it acquired Motorola, right?
Right.
It was part of an effort to get intellectual property under the Google umbrella.
Mm-hmm.
And we've seen that even again with Samsung and Apple in the mobile phone space. Maybe you can comment on what you've seen, because that seems to be an ongoing, almost perpetual battle between the world's two largest phone makers. What are those guys doing, and why is a good offense important to those back and forth negotiations between Samsung and Apple?
Well, if they didn't have a large patent portfolio, either one of them would be trying to get injunctions and stop the other from selling cell phones in the United States. Perhaps a better example would be in the Ethernet marketplace years ago. You had 3Com and Cisco. Huge.
And you worked at 3Com, right?
I worked at 3Com. We had two huge patent portfolios, and it was mutually assured destruction because we could have shut down each other's product lines, and we never went to patent war with each other because of that.
Yeah, sort of the no guns in the saloon détente, if you will, where both companies have enough ammunition to ensure that there is, in fact, no fight. And
as a startup, that's the way you want to be with your competitors. You want to make sure either you're the only one that's armed, or you've at least got enough ammunition to match your opponent and keep them from fighting you.
Mm-hmm. And I would assume that having a good intellectual property offense gives you a pretty interesting understanding of what's out there and the competitive landscape and where opportunity and innovation can maybe really thrive.
Exactly. If you paid attention to your intellectual property early on, you know what your competitor has before they make that phone call to you.
Yeah, that's maybe a little bit of insurance, right? An ounce of prevention is worth a pound of cure.
Yes.
And it's usually more than a pound, I suppose.
In patents, yes.
Yeah. All right. So I think that's pretty good advice to be on the offense and building, constructing, creating value through an intellectual property portfolio as opposed to waiting and finding yourself without assets to include in those discussions. Kind of brings me to our number 8 point on this list, which I always thought was true. Maybe you're going to tell me it's not. Ignorance is not bliss. What's this mean? And I like your little graphic on plugging your ears will not change the truth.
Right, and with patents and intellectual property, if you ignore it, it may be bliss for a few days, but eventually it's going to come back and bite you.
Well, I mean, that was actually a proactive strategy from a number of folks in the past, right? Which was, if I don't know about anything, then I can't possibly be guilty of infringement. Is that true?
No.
If I didn't know and I just play dumb?
No. That one, is totally impossible to do that, and two, that's not going to stop people from coming and knocking on your door and saying you owe license fees.
So you can't just say, hey, I didn't know anything about this field or intellectual property, and therefore I'm off the hook.
No. You're still
ignorance
liable.
is no excuse.
Ignorance is no excuse to the law, I think, is the old saying, and that holds very true here with intellectual property.
So what's the best?
Just make sure that intellectual property is in your mindset as you're building your company strategies, as you're proceeding down. You have to spend a little bit of time each week just checking the intellectual property landscape, checking your employees, make sure that they're not going out on the web and grabbing free software or I wrote this great algorithm for my last company. That's a recipe for disaster.
Well, it brings up a really good point, and it's I guess under the same umbrella of ignorance is not bliss, but how do you drive that sort of culture of innovation where people are thinking about intellectual property and investing in the development of IP as they go about their daily lives, right? I mean, in every startup I've been involved in, the focus is on, how quickly can we build the product, how quickly can we get to market, how quickly can we scale, and how do you ensure that innovation is a part of that rapid development effort, and how do you ensure that people are making IP contributions all along the way? Because what often I've experienced myself is you get to the end of something and then somebody says, oh, geez, we should file a patent on this. And it's either too late for one reason or another, or it's this mountain of work to try and go back and collect everything from a multi-month, multi-year effort. So how do you drive that sense of innovation down to every employee right at the outset?
You feed the engineers. You offer them free pizza. They'll show up for the free pizza, and then you talk to them. And this is what I did at Schneider. You feed them. You give them a quick.
You mean literally feed them?
Feed them.
Yeah.
You give engineers free food, they show up. Particularly in a startup where you're used to living on ramen noodles. If you upscale it to an everything pizza, you've got all your engineers there, and go through. This is intellectual property. Give them a short summary of some of the things they should be watching out for, and then ask them, what are you working on that nobody else has done? And you just write them all down. And those brainstorming sessions, I've come up with hundreds of patents off of that.
Mm-hmm.
And
just by getting people to contribute their ideas and they're thinking about the particular area that they work in.
Right.
Yeah.
You've got somebody, as you said, he's head down, he's got a delivery, and he's just made 3 major breakthroughs to get that product done. But he's still got to get the bugs out of his code, which is what's on the front of his mind. But if you take him out away from the screen for an hour to eat some lunch and think about it, these are the things that make our product 10 times better than anybody else's. These are the things we want to patent.
And as they're thinking about those things, it can be something very specific, something very broad, somewhere in between.
Could be anything.
Any of this.
Right.
Okay.
Sometimes it's just this very small little bit of code that makes your product work 10 times faster than anybody else.
And being able to protect that's obviously
that gives you 20 years of protection over the fastest product in the market.
All right, cool. So let's skip ahead here to number 9, which involves a bunch of letters and I guess acronyms here. CYA-NDA, which stands for Cover Your Ass with a non-disclosure agreement. And Rich, your number 9 tip here is CYA-NDA. So I'm assuming here that this is about being proactive in protecting ideas, right? And maybe we can talk a bit about how you do that, what an NDA is, who it's sent to, what its requirements are, etc.
I mean, most of what we've been talking about has been in-house. Thus far has been talking in-house, looking at your developers, but you need vendors. You need to send your product out to have somebody manufacture it. You may need consultants for certain ideas. These people are going to learn about what you're doing.
Mm-hmm.
And they could easily take your ideas and go patent them themselves, or they could use your customer list or your design, which some of your design isn't going to be patentable, but it's a trade secret. You've just spent $3 million to design the circuit board and all of the mechanicals around it. You don't want somebody taking that down the street to another company to manufacture that.
Okay, so let's stop for a second here and think about where we are, which is I'm a founder. Mm-hmm. I'm working in a 3-person company. We're just getting started. We're a couple months into this thing. We haven't taken any outside capital yet. Who do we need to ensure is not only holding things confidential, but also assigning inventions they might come up with to the company? Is it just me and the co-founders, every employee, every consultant? What if I get some ideas from the outside? How do I ensure that that's covered? Because it seems like, at least in my own experience, there's been a number of times where good ideas can come from most anywhere. and how do you ensure you've got the proper documentation in place to protect what is, an idea developed for the company?
You need to be diligent about everybody. That means each employee, each consultant you bring in, all your contractors need to sign an agreement, basically assigning the invention or anything they're working on at work at least to the company and saying that they won't disclose it to anybody else. So that puts the value into the company. In the United States, the inventor owns his invention by default. And with employees, you want an agreement when you hire them that in exchange for your salary,
right,
you're assigning any inventions you have.
So that reminds me of a story. I think I have this roughly correct. Maybe some of the details are slightly foggy, but Skype was acquired by eBay. But it wasn't until eBay sold Skype to Silver Lake and then Microsoft, but specifically to the private equity team at Silver Lake, that they realized eBay had not acquired the intellectual property, the core underlying intellectual property to the algorithms that did audio compression and were really the core engine of Skype. Mm-hmm. And they had to go back and perfect that, right, because it hadn't been done properly at the outset. And they ended up spending like an additional, what became $1 billion to get the IP of having acquired the company. And so it was sort of this big oops moment. And I've heard of similar stories from large and small startup companies where they were going back and chasing former employees for NDA agreements that were never signed, assignment of invention agreements that were never signed, to ensure that everything that had been developed belonged to the company, and more importantly, that there couldn't be some future risk. That was really the issue as this one particular instance I'm thinking of. It was an M&A process where the buyer was concerned that one of those persons who was no longer part of the company could come back and say, hey, I never assigned my rights to the things we as an engineering team or a product team developed.
Right. So you need those agreements, and you need to save those agreements. You need to be able to find them, which, in startup mode, sometimes papers like that get lost, and you need to keep them in one solid place.
Yeah. So I think the big lesson here is to not find yourself in a bad spot later, but to start early and build really simple processes and systems for tracking all of this.
It's not a lot of work.
Interested to get your thinking on documents, right? These things, I've seen them as small as 2 pages and as big as 20 pages, right? What's necessary?
Usually it's very, very small, and you're best to get an attorney to tell you exactly, but there's plenty of these out on the web.
Yeah, you can just grab a sample, and it's really a couple key points, right?
Right.
Confidentiality, non-disclosure, right? Yes. What we say, do, and talk about remains between us.
For employees and contractors, promise that you won't take somebody else's intellectual property and put it into the product.
Sure.
And assignment of any invention.
And that can be a single document?
Yeah, it can be a single document, each one of these being a paragraph.
A couple of pages, boom, 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 ready to go.
Easy. Yep.
Yeah, I think that's a good way to try and manage it versus, I'm meaning from a proactive standpoint as opposed to retroactively.
Right, and you need to keep these documents for like 20 years. I've had times where I've had to go try to find inventor agreements from people that had left 10 years earlier. Even for large-sized companies, that's not easy.
Okay. Well, all right, I got it. CYA, NDA it is. So let's move on to number 10, and this is always interesting. IP is more than just patents. Yeah. And so you hear people talk about patents and IP, and I've probably done this today in our webinar, talked about patents and IP almost interchangeably, but patents are simply a subset of a much larger umbrella that is intellectual property. So what sorts of things constitute intellectual property beyond just patents? And maybe we could talk a little bit about each in some detail.
Sure. In addition to patents, you've got trademarks. Trademark is your name. That's your brand. This is kind of like from the marketing side. You've gone out and built goodwill around your company. You've built a reputation. You don't want somebody else copying that. You know, the Ritz-Carlton goes out and has this pristine trademark for very elegant, opulent.
Is that the kind of place you hang out, Rich?
No.
So this is just a hypothetical
example.
This is
a hypothetical.
Okay.
But, you know, you could have another company, without trademarks, you could have a company that gets bounced out of Motel 6 for not meeting their standards and name themselves as the Ritz-Carlton.
Right.
Well,
like we've seen that in China, like there's a Starbucks or something like that.
Yeah.
It's almost identical to Starbucks, but it changes a single letter. You don't see that in the U.S. or most European countries because of the enforcement of trademark and copyright.
It does happen, but very quickly, usually the Ritz-Carlton would send a cease and desist letter and shut it down. So for a startup, you want a unique name, something that nobody else is using. So you've got to do some trademark searching, search around the web.
Okay, and so
otherwise
that is,
you'll have another company call you, say, you've got to change your name after 3 or 4 years being in business.
Yeah, and that's the T in USPTO, right?
So
the
trademark.
So it's the U.S. Patent and Trademark Office,
Right.
and the Trademark Office, I think, also has some online resources.
Exactly.
Right, where you can go and search names or I think even phrases and that sort of thing.
Yeah.
And this would include what? What sorts of things can be trademarked?
Certainly company names, product names, symbols. There's other things that can be trademarked. That's not my specialty, but it's one of those things I know, okay, this is an issue, send it off to an attorney or somebody that does know that.
And how about copyrights? Software can be copyrighted, books can be copyrighted.
Music.
You always see that on the TV, you know, this broadcast is copyright property of.
Right, music,
Sure.
videos. And this is something the entrepreneur needs to take care of. When you go to do that video for your Kickstarter campaign, you got to make sure you have rights to that music, or you could get shut down and have to pull stuff off of your.
And redo it with some elevator music or something that's not copyrighted.
Or just pay the copyright fee. There's companies out there, Copyright Clearance Center. There's a number of music clearance centers that you call them. They'll get you the rights to the songs that you need, and it's usually short money.
Yeah. But same with images too, right? Like Getty Images and Photostock, Shutterstock. I mean, Imager. There's any number of big, massive image databases where you can get rights-protected media to use on websites or product brochures or all those sorts of things that an entrepreneur would want to build.
Mm-hmm. And copyright, you can register with the Copyright Office, but you don't need to. You just have rights to that as the artist that creates your software or your specifications, your books, or your music. Okay.
And this other interesting delineation is, I think, pertinent to the entrepreneur who's building a startup company today, because not everything's patentable, right? It's become much, much more difficult to get, for example, a business method patent,
right.
Or to get a software patented or an algorithm patented. Some of the things that we saw back in the last decade that were coming through were, hey, I'm gonna have an auction business and that's patentable, or I'm going to have an algorithm that does this and that's patentable. And some of those changes that we talked about, like that brought along fast track, et cetera, also brought about some changes relative to patents on things like software and business methods. Can you talk about some of those changes and why, if patents are difficult, trade secrets become increasingly important?
Right, and that's an evolving area of law on software patents and business methods. There's been a lot of pushback, and a lot of patents have been invalidated in those areas recently. And for companies, you've got trade secrets that you can use to protect that.
What's a trade secret?
It's just something that you keep as a secret, something you mark as confidential that you don't allow anyone else to know about. So this is where your non-disclosure agreements are important, and that your employees have confidentiality agreements, that they agree to keep your secret secret. Your customer list would be a trade secret, for example. You can't patent that.
Or a process, a business process that you go through to do things, or
the Coca-Cola formula is a trade secret, and they wouldn't want to patent that because your patents are only good for 20 years, and you actually make it public. Right. But trade secret you can keep forever as long as you can keep it defended.
Yeah, and so I think that's maybe an interesting point, especially as we think about entrepreneurs who are early in the business building cycle. There's certainly a real clear and valuable effort in building things like patents as part of intellectual property, but also just being thoughtful and careful about how you do things and protecting those as trade secrets can also have tremendous value.
Right.
And make it really difficult for people to sort of unwind exactly how you maybe build a product or how your software really works.
Correct.
Yeah, that's cool, and that doesn't require anything other than a diligent effort to keep things confidential.
That's correct.
All right, so with that, I guess we can think about intellectual property as including certainly patents, but also trade secrets, copyrights, trademarks, service marks, etc.
Mm-hmm.
All right, so we're coming up on the end here. Number 11 is the end game. Let's talk, Rich, a bit about why it's important to know your end game, and do we need to know this right at the beginning?
Well, you should, because particularly if you're focused on intellectual property, you're focused on patents, you've got a hard asset there. When you go to do your exit from your startup, you've got something to increase the value, because you say, not only do you have some things that a bunch of engineers worked on, you've got something the U.S. government has put a stamp on that you own as a hard asset that increases the value of your startup.
Yeah, and I think it's really probably important to think about not just getting patents, but the process of getting patents and how that becomes part of the company's culture.
Yeah.
And everyone's innovating, right? But building innovation as an objective into the overall culture of the organization is an important thing to ensuring everybody's constantly thinking about how do we do it better, how do we do it differently, how do we do something more unique than what's in market. Really creates that constant and ongoing undercurrent that drives innovation.
I've worked in through a couple of major acquisitions, checking all of the software to make sure that there's no open source software, or that you have the rights to open source software.
Improperly used open source, right? Open source is cool, but you have to use it properly.
That's correct.
Right.
And that's part of the due diligence. If you haven't paid attention to intellectual property through your building of your company, you may have your whole M&A deal fall through because of open source problems, or because you don't have,
or you didn't pay a license fee to someone who you ended up with some piece of shareware, and you didn't pay the fee, and the thing is sitting somewhere buried on a server.
Or the Skype example you had, where you didn't actually own the intellectual property because some inventor that left a long time ago actually owns your core IP.
Right. You don't want to get halfway through making the movie and learn that you don't own the rights.
That's correct.
That's not a good place to be.
You can see millions disappearing out of your bank account very quickly.
Yeah, and you don't want to do that later. You want to do that early. So always start with the end game in mind. I think that's good advice. We're coming up on the hour here, so I thought maybe we would move over to a quick recap of the 11 tips, and then take some questions. So let's run through this once more. Rich, I think you did a good job of driving home the point of start early, start early, start early. We got it. We'll file early. Coming up, number 4, the cost of a patent. We talked about some ways to do that very inexpensively, getting the idea on file for as little as $130, and I think that's awesome. But yeah, kind of planning out in time for the life of something,
right.
5 to 15 or more as a good number, but that doesn't come all at once. And so I think that was really educational in terms of, hey, we can do this on the cheap, we can hack the system in a way that lets us be involved, that lets us avoid using lawyers, and do it in a way that's also quick, as we look at number 5, which is the fast track. I think that might be today's best piece of advice. No offense to your other great contributions and insights, but I think this idea of the fast track is really important to entrepreneurs, which is being able to assure that you get action within 12 months is I think, super powerful, and something that really sort of changes how I, as a founder, think about intellectual property and patents in particular as part of the process of building a startup. Getting an asset like that early is invaluable. You know, I think being able to do that for as little as an incremental $2,000 is a fabulous ROI. Absolutely. On protecting core value created within the startup. And then 6, lawyers are good. They can create some nice things, but it's not necessarily a requirement. And you don't need lawyers in order to get a U.S. patent, right?
Oh, right.
All right. And the best defense being a good offense, right? So if you want to be successful down the road when somebody's looking for a royalty, it's always nice to have some IP of your own.
Correct.
In the 8th slot, ignorance is not bliss. Pay attention. Be proactive and thoughtful. You can't bury your head in the sand and plead ignorance.
Right.
9, cover your ass with an NDA. Make sure that you got the folks signing and contributing their inventions to the organization, along with agreeing to retain everything as confidential. Mm-hmm. 10. Pretty good explanation of everything that can fall under the IP umbrella: trademarks, copyright, trade secrets. And I think the trade secrets piece is really thoughtful as well in terms of thinking about how we protect those things that are unique to us and our startups. And then lastly, start with the end game in mind. Know what that's good advice for any startup in terms of thinking about their plan, which is it's always good to know with where you want to end up at the start of the negotiation, the start of the process, the start of building a company and a culture. Know your end game and where you'd like to end up before you start. So knowing your end game is critically important. That's great. Hey, I really appreciate your time today, Rich. Let's now jump over to some questions. As a reminder, to submit questions, simply go to your control panel on your GoToWebinar screen, and we certainly encourage and appreciate your participation in asking questions. Let's dive in here, Rich. We've got about 5 minutes or so. First question: how long does the patent last? 20
years from your filing date, generally. I mean, there's minor exceptions, but generally that's the rule.
Okay. What does patent pending mean?
It means you've got a patent that's on file with the patent office, but it is not yet issued as a U.S. patent.
So you could claim something as patent pending as soon as you file that first
provisional.
First provisional?
Yeah.
It's pending.
You've got something pending.
So $130, short description, more than 2 pages, but a short description, and I can say patent pending when referencing my idea publicly.
Right.
Cool. Let's see. Here's one. Doesn't patent protection decrease innovation in today's fast-paced technical environment?
Absolutely not. You get much more innovation because of the patent is essentially a contract. You get 20 years of exclusivity on your idea for disclosing it. And once it's disclosed, somebody else can build their invention on top of yours, and it becomes a brick wall of inventions.
Let's see. How do you know if an idea is patentable?
Well, the first thing is somebody else doing it? Has somebody else invented it? If somebody else has invented it, then it's not. Then you get into some of the hazy areas. Is it obvious? That's tough. Is it patentable subject matter? That's an area that the Supreme Court is debating.
So where do you really start with this as an entrepreneur? If I want to know if my idea is patentable, you go out and do a search?
You can do a search. You can hire an attorney to take a look at it. You know, for an hour, somebody can quickly talk through and say, in general, this is or this wouldn't be.
Yeah, you get a pretty good sense.
Yeah.
Could I call that number and run my idea past those people and get an opinion or not?
They won't give you legal advice.
They can't give you legal advice. Okay.
Right, so they won't answer that one.
But with an hour of time, somebody could tell me, hey, is this patentable? But I think ultimately you don't know the answer to that question until you've gone through the process.
Right.
Right? Here's a pretty interesting question. If I missed my window, meaning the 12 months, do I need not pursue my startup?
No, you can pursue your startup, but you start looking for ways that your product is unique that you haven't disclosed yet. As you do improvements, start patenting your improvements.
Yeah, I mean, I think that's one thing we wanted to be really clear about, and we talked at the outset how patents are an important and valuable piece of the startup process, but by no means are they required, right? I've been part of, invested in, participated in, and seen a ferocious number of startups that have been wildly successful without patents or a large set of patents. That being said, it's additional value you can create, and hopefully today we've outlined a roadmap that lets you think about how to create that value. But to the audience member submitting that question, by all means, pursue your startup idea. Doesn't mean you can't be successful, but to Rich's point, start thinking about how you can expand, extend, and move beyond your initial idea, because I think that's what happens. Startups evolve, they pivot. What was core one day may not be core the next, and the opportunity for creating intellectual property can grow as the startup grows.
And you can go out and buy patents. Sometimes if you're in a niche area for short money, you could buy a patent to give you that protection that you lost.
Yeah. Hey, there was one question of clarification here. The question is, what's the name of the USPTO procedure to file an idea for $130?
It's called a provisional patent application.
Provisional patent application.
Right.
And under the small entity?
Small entity, it's $130.
$130. So it's the provisional patent. Let's just walk through that very quickly. Provisional patent, $130. And then you have 12 months to then file. What's the next thing?
It's called a non-provisional utility patent application.
And that happens up to 12 months later.
Correct.
And costs $730.
About $730 to file.
Okay, and that's the non-provisional. So provisional followed by non-provisional patent application.
Right.
That's the formal application.
Non-provisional, you get no patent, no examination of it. There's nobody that reviews it. You're for provisional. For a non-provisional patent application, you get an examination. You get an examiner to assign to your case to review it.
All right. I think that just about wraps up our time, Rich. I really appreciate your wisdom. You're a good friend and colleague, and it's always nice to get together at Talk IP. But again, thank you for your insight, and we especially want to thank our friends at Co-Founders Labs. They've been great partners, and we really, truly appreciate them having us today. It's been a pleasure, and we certainly hope that the founders and entrepreneurs who participated with us today have learned from what we've presented and can hopefully use some of these tips to build their startup companies. And we certainly welcome the opportunity to work with those entrepreneurs who are interested in learning more about intellectual property. So if you're looking to become an entrepreneur and you're searching for a good idea, you can certainly check out our portfolio of opportunities at founderswanted.com, or you can drop us a line. You can reach me or Rich at founderswanted.com, Mark at founderswanted.com. You can follow us on Twitter. The handle's @wanted, and we'll certainly make available these tips, a recording from Co-Founders Lab, as well as founderswanted.com/11 tips. So with that, I say thank you, have a great day, and remember, IP matters.